Thanks for checking out SYMFONI on YouTube. Please be sure to subscribe and like our videos for updates.
Oh, sorry. Good morning, Leonard 6. Sorry. Please, closer, please. Are you ready? Sharp.
Which one do you want me to do?
Sorry.
Minister, would like to know how it went through today.
All right. It's good to say that the application has been taken. And the summary of what has been argued this morning is that the federal government tried the applicant, Dr. Orji Kalu, for 12 years. He was convicted and sentenced. He served 5 months in the custody of the prison service, and because of errors contained in the judgment of the Federal High Court, he was released. They then served him hearing notice to try him again after 12 years. And we are saying that is unfair. The weight of the federal government is too much to place on one man. 12 years, and then you start another journey, you don't know when it will end. Judicial journey is always long. Let nobody give you the impression that you can take somebody to court and in 1 minute you have sent him to jail. There are so many tenets of fair hearing that a person must receive before he ends up in jail. So the application is simply to say, you have tried now, no kill this man, to put it in the balance which the ordinary man will understand. We are saying you don't try. 12 years, you know, if you try him for granted. Let him please enjoy his life. That's what we have argued today. And the federal government has made its position clear. And the ball is now in the court of the deciding judge. Thank you.
Well, the matter is a very straightforward one. For the first and third defendant, there was no order of any court, even the Supreme Court, directing a retrial. And that is what we are saying. Show us the order of court, and the prosecution had none. So without an order of court, the Constitution says in section 36(9) that there cannot be a retrial. It's very, very clear. And that's where we stand. Show us a copy of the order of court. And the prosecution was not able to do that. And until that is done, there's no way any court of competent jurisdiction can order a retrial. Pure and simple. Thank you. Well, it's only in our country that this kind of thing will happen. And I hope that in some other jurisdiction you can't find this kind of application and still practice law. You see, everything goes in our country. How will a party, Udeogu went to Supreme Court, who got the order, also spent like the same 5 months in prison? The Supreme Court considered that he has stayed 5 months in prison and they go back to High Court. So if he's granted bail, or if he's not granted bail, will he stay there? And after staying 5 months, will he find an application that he can no longer be tried?
So these are absurd situations that are, they rely on section 36(9) of the Constitution. The Constitution says that if the court who try a person is not competent, then there will be no trial. The trial will be null, and and then you cannot you can retry that person in the lower court. If you are relying on issue of double jeopardy, the Constitution is saying that you must have been tried by a court of competent jurisdiction, and if the court found that a court of competent jurisdiction try you, and there is an error, then the order of the trial can be made to the lower court. Here, there is no. The Federal High Court ruled that there is no court of competent jurisdiction that have tried him. And yet you are relying on that section to say that I can no longer be tried twice. So it's absurd. This is a kind of application that should not have been filed in first instance. But in our country, I pray that we grow. Because this kind of thing, as I was emotional about it, I do not expect a lawyer to file this kind of application. And I do not, the kind of attention that is given to this case, I do not expect it. This kind of application. Can they go before the trial judge and raise the same issue? You now file a different action, stay the other case. Contrary to the Administration of Criminal Justice Act, they said that there must not be stay. So it's very, very suspicious, and we don't know what is going on. So that is why we are emotional in arguing this application. Thank you. Yes.